you were placed on Rules Committee.
Tom, did you see my note from yesterday?
I did. Okay. Yeah, we are.
We called a couple weeks ago, but we're just trying to make sure.
She mentioned that.
Just let it go. Rules Committee come to order, and thank you very much for joining us this afternoon. Today, the Rules Committee will consider H.Res. 1732, the Regulatory Integration Integrity Protection Act 2015. We've also just added two additional items, which we were speaking with our friends, the Democrats, about a conference report to accompany H.J.Res 11. And we're expecting Congressman Yarmouth, and I saw him earlier walk in here, and the chairman of the Budget Committee, Mr. Price, is expected up here about the signature of the senators and the House members agreeing to that. Secondly, we also are going to add H.J.Res 43, the disapproval, the actions of the District of Columbia in approving the Reproductive Health Non-Discrimination Amendment Act of 2014. And there will be a discussion later in the, after these two panels are done, that we will have on that issue. H.R. 1734 rejects the administration's repeated efforts to unsuccessfully and, we believe, unnecessarily expand federal jurisdiction and regulations over additional bodies of water under the Clean Water Act. Facing bipartisan opposition in Congress, the President has once again sought to unilaterally rewrite the laws through the regulatory process. This bipartisan bill protects the role of the state and local governments in formulating of regulations that affect water in their communities. I want to welcome the young chairman from Ohio, Congressman Gibbs, and also Congresswoman Edwards, and I would invite them to come up to the table at this time. And I want to thank them for their work on 1732. I'm delighted that both of you are here. I think it's important to remember that for us to be able to hear you, I'd love to have you turn on your microphone as you choose. And before I actually defer to you, I want you to know anything you have in writing. We welcome that as a summary, but we'd like to get a copy of that for our great stenographers who are here with us. And I'd like to, if I can, yield to the gentleman from Massachusetts for any opening statement he would choose to make. Gentleman's recognized.
Welcome, and I look forward to the testimony. I yield back.
Thank you very much. Boy, how succinct we are at the Rules Committee. We're delighted that both of you are here. Ms. Edwards, you may know this because you've been here before. I want and need you to know that this Rules Committee is open to make sure we hear from you. The committee members here are intensely interested in what you're bringing forth today, as well as the gentleman, Mr. Gibbs, from Ohio. But I need you to know that we're delighted that you've taken time to join us today, and we normally have a fuller house. Today's a busy day, as we all understand. Mr. Gibbs, welcome. Gentleman's now recognized.
Thank you, Mr. Chairman, and you're right in your opening statement. This bill tells the EPA to stop with the proposed rule, the Army Corps of Engineers. 32 states have commented against this rule, with almost 400 counties have requested the EPA withdraw or significantly revise the water rule. More than 1 million comments were filed during the comment period in the proposed rule, and almost 70% of those were substantive comments that were opposed to the rule. The proposed rule is a clear expansion of the EPA's jurisdiction under the Clean Water Act and flies in the face of 2 Supreme Court decisions. The agency has admitted to Congress in multiple hearings, and we even had a joint hearing with the United States Senate, that the proposed rule has created confusion and uncertainty. The Clean Water Act was originally intended to be a cooperative partnership between the states and the federal government, with the states the responsibility to eliminate and prevent an oversight of water pollution and improve our water quality. This has been, I think, a successful partnership that has provided very big improvements in water quality throughout the nation since it was enacted in 1972. And not all waters are subject to federal jurisdiction. And I think that's an important point to remember. This is a big power grab and expansion of federal jurisdiction of waters, but waters that aren't under most people's minds, navigable in the rational sense. They're being regulated by the states under the Clean Water Act, and I think they're doing a good job. We've come a long ways. Not to say there's not challenges out there, but I think when you have regulation closer to the people at the local level, at the state level, we can do a better job. I know several of my colleagues across the aisle would like us to wait until the end of this rule is finalized before taking action, but then there's little chance of anything to do to fix that. The problems will be created. One thing we've heard during the committee process from the EPA Administrator Jeannie McCarthy and Assistant Secretary of Civil Works Darcy, that all our concerns have been raised, that they're fixing it in the final rule, and they sent the final rule to OMB, and I requested several times to share their, quote, fixes with us, and they said that wasn't necessary. They were moving forward with the proposed rule to implementation. This bill gives the agencies and their state partners and stakeholders another chance to work together to develop a rule that was intended to provide clarity. And we are hearing during the committee process from stakeholder groups out there, entities, that they do want clarity. But the way the EPA and the Corps have went about this, it's providing less clarity and more confusion. And like I said just a moment ago, that they've pretty much even admitted that I've said that. The Regulatory Integrity Protection Act requires agencies to withdraw the proposed rule and enter into a transparent and cooperative process with the states, local governments, and other stakeholders to write a new rule. That's what the EPA should have done in the first place. They did not engage the states in the beginning of this rule that they put out a little over a year ago now. The Regulatory Integrity Protection Act will ensure that all agencies cannot repropose the same broken rule they released a year ago. It does give the agencies an opportunity to get it right. Approximately $220 billion in annual investment is tied up in the issuance of Section 404 permits by the Army Corps of Engineers. The executive branch needs to provide certainty to stakeholders during the rulemaking process and ensure that these significant investments continue. So I want to thank the Rules Committee for taking this up for consideration of H.R. 1732, and I ask for your support. I yield back.
Bob, thank you very much.
Questions on the time.
Yes, sir. And thank you very much. If you have anything in writing, you just leave it here on the desk.
I will.
We'll get that. Appreciate it. Ms. Edwards, we're delighted that you're here, and you're welcome to now proceed.
Thank you, Mr. Chairman. And I have an amendment that would to the committee print on this bill, and I really appreciate your consideration. I don't come up here often, but when I do, it's because I really want to be here. And so I thank you for your consideration. As a member of the Transportation and Infrastructure Committee, I want to lay out our Democratic opposition to the so-called Regulatory Integrity Protection Act, and I want to explain why I've offered an amendment to that. For my colleagues, this rulemaking really is about clean water. And thanks to the Clean Water Act, billions of pounds of pollution have been kept out of our rivers, and the number of waters that meet clean water goals nationwide has actually doubled, with direct benefits for drinking water, public health, recreation, and wildlife. This is especially true for my home state of Maryland that's within the 5-state Chesapeake Bay watershed. As you probably know, the Chesapeake Bay is the largest estuary in the country. Several of its tributaries, including the Anacostia, the Patuxent River, the Potomac River, and the Severn Rivers, actually run through my congressional district, the 4th Congressional District of Maryland. The Chesapeake Bay watershed is actually fed by 110,000 miles of creeks, rivers, and streams. And in fact, 70% of Marylanders get our drinking water from sources that rely on headwater or seasonal streams. Nationwide, about 117 million people get their drinking water from these type waters. However, due to 2 Supreme Court decisions, there's widespread confusion as to what falls under the protection of the Clean Water Act. That's why the Obama administration is working to finalize their joint proposed rule clarifying the limits of federal jurisdiction under the Act. And that's precisely what the court instructed the federal government to do under the Swank and Rapanos decisions. That was 14 years ago in 2006, 2001, and then subsequently the decision in 2006. Along with those 2 Supreme Court decisions, the Bush administration followed the exact same process in issuing 2 guidance documents in 2003 and 2008, which coincidentally remain in force today. Indeed, that's actually part of the confusion. It's these 2 Bush-era guidance documents that have actually compounded the confusion, uncertainty, and increased the compliance costs that are faced by our constituents. And I would say that we have heard in our committee, both from opponents and proponents, that they just want clarity, and it's this, and the rule seeks to do that. And you don't really have to take my word on it, Mr. Chairman. Let me quote from some of the comments that were made in opposition to the Bush-era guidance. According to the American Farm Bureau Federation, and I quote, "With no clear regulatory definitions to guide their determinations, what has emerged is a hodgepodge of ad hoc and inconsistent jurisdictional theories." In fact, during the rulemaking process, more than 1 million comments have been received. 208 days has elapsed since the beginning of the process. 400 public hearings all across the country have been held. And in fact, as late as April 6th, just a few weeks ago, the Environmental Protection Agency and the Army Corps of Engineers issued a rule based on concerns that were expressed during this process. H.R. 1732 would actually halt the clean water rulemaking and require the agencies to withdraw the proposed rule and restart the rulemaking process. It would force the agencies to meet with the same group of stakeholders again and talk about the same issues again that they've already discussed several times over the last 12 years. And in fact, the rulemaking has actually been more than a decade in development. Moreover, the bill would further perpetuate the current regulatory confusion that leads to unnecessary costs and delays, and which has been the subject of much criticism from all stakeholders and will leave many of our nation's waters completely unprotected. This week, we're also going to vote on the Energy and Water Appropriations Bill. It contains a policy rider that explicitly prohibits the Army Corps from spending any money to develop the very same new clean water rule that this bill tells the Corps to write. From my understanding, the Interior Appropriations Bill is also expected to contain a similar rider for the Environmental Protection Agency. What's happening here is that the supporters of trying to stop this rulemaking make it sound as if all they want is for the EPA and the Corps to develop rules right away. But it's really clear that what they want is to stop the agencies from doing their job at all, stop them from actually writing a rule that responds to the Supreme Court's decisions. And you know what? In my view, Mr. Chairman, that means you don't have any rules, we won't have any clean water. I think it's time for Congress to allow the administration to finish its work, to publish the final rule, and if we don't like the result, we actually have adequate opportunity and authority to fix it. In fact, Congress has the ability to review major rules issued by federal agencies before the rules take place. The Congressional Review Act allows Congress to actually disapprove new rules, resulting in the rules having no force or effect. We just need to let them get to a final rule. If H.R. 1732 were to be enacted, it would only ensure that the confusion continues and these sources of drinking water remain a risk to public health. And so I'm urging our opponents, our colleagues, to oppose the bill. But what my amendment would do, to be fair, is that several of our constituents all across the country have also expressed concern to the agency, millions of comments, as I've said, with the substance of the proposed rule. I've listened to some of these concerns from my constituents as well, and I've asked the agency witnesses who've appeared before our committees, our subcommittees, as the chairman has described, our joint committees between the House and the Senate. And we've heard from them. And so the administration's answers are really say that the claims are false, and we've been assured that. But let's try to get to the core. My amendment would address these concerns, saying that if any of them prove to be true, if those concerns prove to be true, then the Secretary and the Administrator are actually prohibited from issuing any final rule that would bring about these occurrences. So instead of using a legislative scalpel, what my colleagues have decided to use, frankly, is a meat cleaver. And so in my amendment, I've tried to address those concerns that I've heard repeatedly from our constituents. Under my amendment, the administration cannot expand the scope beyond water bodies covered prior to the decisions of the United States Supreme Court in these two cases. In fact, in my amendment, we explicitly say that it cannot be inconsistent with Justices Scalia and Kennedy's judicial opinions and Rapanos. In addition to that, they can't increase the regulation of ditches. Some people have said that this is attempting to increase the regulation of ditches. My amendment says they can't eliminate any historical, statutory, or regulatory exemptions for agriculture, which do not exist under the 2003 and 2008 documents. These are questions about ditches under 2003 and 8 guidance, and they're interpreted differently in different parts of the country. but my amendment makes it clear that if they are inconsistent with the justice's rulings in Rapanos, then they cannot be executed. To me, the federal government is trying to use its authority to do the right thing by providing certainty to the regulatory community and protecting human health and environment. But as a fallback and assurance to the regulated community, I am urging the committee to make my amendment in order that would include clear legislative restrictions on the final rulemaking, addressing the range of concerns that have been expressed by stakeholders. And though the EPA has made clear in testimony before our committees and our joint committees that they're not doing that, nonetheless, I offer this amendment as a backstop in the unlikely event that anyone would think differently about whether we're trying to regulate ditches, streams, and farmland. And with that, I would yield. Thank you.
Ms. Edwards, thank you very much. I'd like to notify, we have several members that are in our audience. I'd like to advise them that we're on a one-vote series right now, one vote during that discussion and series, and we're on that right now. And I would encourage them to go vote as we will continue this hearing and work all the way through this. So once again, I would encourage any member that we have that's sitting in our crowd to please go vote, because we will continue through this.
Mr. Chairman, I would also leave with the committee letters from mayors and organizations and some of our legislators in support of the rulemaking.
Without objection, we'll enter that in the record. Thank you very much. You'll include that with the other testimony. Mr. Gibbs, this administration has decided really to begin this process avoiding Congress. Did they come give notice to Congress and hearings were held and they told you what they wanted to do? They went and met with people around the country? Tell me the process that this administration is following.
They had the comment period, and then they extended the comment period, and that's when they had the million or so comments come in. And then after the comment period expired, they said they had held 400 stakeholder meetings out throughout the country. And excuse me, I requested at the committee that they give us those locations and times and dates of those meetings and who they met with. And they haven't supplied the committee with that information yet. But speaking to stakeholder groups out there, there was some meetings held around the country. I don't know if there was 400, but it was more of a lecture process. They didn't really take input. They pretty much, my understanding, they were told at the meetings what they were proposing and what the reason it was needed. And I'd like to also expound a little bit, Mr. Chairman. My really fear of this, if this rule is implemented, that we actually go backwards from water quality in this country. Because when you layer on more red tape and bureaucracy and cost, at some point people throw their hands up in the air and they say, I can't do this. It's an adversarial relationship. And what this does, when you expand waters in the United States, really what it does, it opens up the door for additional permitting, especially Section 404 permits, where landowners, farmers, developers, local governments, state governments would have to go and get permits from the Army Corps they don't have to get now. And all that does is just add cost and time delay. It doesn't going to do anything to improve or enhance our water quality or the improvements that we've made. And so I'm really concerned about that. And then also concerned about the issue about, navigable versus the expansion. And basically what the US EPA has said in the expansion is substantial nexus. If it has waters that have substantial nexus being biological or chemical, that would flow under their expansion of waters in the United States. Well, they did a study. It took them about a year. And I think the study pretty much told them they learned that water flows downhill. Obviously, non-navigable waters flow into navigable waters. That doesn't mean that we should expand the jurisdiction and put it under the permit process and under the laws of the Clean Water Act. And also, it's important to remember, during the Clean Water Act, when it was passed, we had serious pollution, point source pollution problems in this country. And we put serious penalties, fines, and maybe even jail time on serious polluters. And this opens up the door to landowners, homeowners, to those type fines, which I don't think anybody in this body, Republican or Democrat, would want to see happen to innocent people out there when you expand this jurisdiction. So we did have, in one of the committees, we had an example of one of the core districts declared a farm field, waters in the United States. And when you do that, because of the connectivity rule, the adjoining landowners get pulled into that. And they had to get special permitting, 404 in particular, and it's cost hundreds of thousands of dollars. Time to did all the studies. And this is just laying on a bunch of redundancy and red tape and bureaucracy. I think we could actually go backwards from where we've gone since 1972.
Mr. Gibbs, who do you believe the primary beneficiary of this rule would be? Who's going to gain from this?
Mr. Chairman, I think the federal government, the U.S. EPA, because what will happen when you expand that, like I said, it opens up to more permit requirements under Section 404. So the Corps is going to have a lot more work. I don't know if they're too excited about that. But the money that comes into there, but what it does, it centralizes power here in this town. And it takes away power from the states. And that's why 32 states adamantly came to opposition to this rule. And I don't think that's something we should forget. And like I say, almost 400 counties. And all we're saying in this proposed legislation is stop, go back, work with the states, because initially they didn't work with the states. I talked to my state EPA director. I said, did you have any conversations or know anything about this? There was no interaction with my state of Ohio before when they were developing this.
Likewise, I'd ask, who's going to be hurt by it?
Oh, hurt is, there's no doubt. Landowners, real estate people, developers, local governments, state governments. That's why in one of our hearings, we brought in the local government people and the state government people, and we had testimony from them, and it was quite telling, because all you're doing is going to put them into the permit process. And when you go in the permit process, and especially this opens up the door to a lot more potentially permanent applications, that you're going to have delays. So when you're starting to get projects done at the local level, it's going to be delays, and you're going to go through the federal office, and it really takes authority, jurisdiction away from the states. And, you know, I'm a firm believer if we can keep things closer to the states, and that's, you know, remember when the Clean Water Act was passed, it was passed on a cooperative federalism where the states would implement and enforce the Clean Water Act under the guidance of the U.S. EPA, the federal government. That's why every 3 years they have to submit a plan of action to the feds, and that's the guidance part. And, you know, I think it works better when we have state and local people, regulators that are working with in their communities, that they know what's best in their communities. Because when it comes to water, there's a lot of different challenges all around the country because there's different situations and what's happening in all different water bodies.
I really just want to make a quick comment. I live, my district includes Mobile Bay and the Mobile-Tensas River Delta, which is one of the 2 or 3 largest deltas in the United States of America. Water quality is absolutely critical to us. It defines who we are. Every local government that rings that bay and that delta have contacted me directly or my office against this rule, because it takes away from them their ability to do the things we want to do to protect our water. It's actually, and I think this was your point, it's actually anti-clean water in that respect. I've also heard from farmers, not big farmers. We don't have big farmers. We got small farmers where I live. They're terrified of this, what it would do to their ability to continue to farm, not just farm in any general sense, but farm in a sense where they can sustain their family farms generation after generation. We also have a lot of small forest owners, people that don't own thousands of acres, but a few hundred acres. And those few hundred acres are precious to them. They may cut a little timber off of it now and then, but this is not a big money operation. They're terrified of this. So here I am in this very ecologically sensitive area with all these people who depend upon this. And to a person, they are seeing me directly or calling my office and saying, please do something about this. So I applaud you for bringing this. I know the administration is against it, but it's time that we recognize that there is a reason in this country for local and state government to have power over certain local things, and I think this is one of them. And I yield back, Madam Chairman.
Thank you, Madam Chair. I just want to begin by kind of calling attention to the fact that you know, we're discussing the bill before us right now, but 2 other measures have been added to the calendar at the last minute. A bill that attacks women's reproductive rights in the District of Columbia, and then a budget conference that we just, I think we were noticed about it, the text of which we were available at 3:09 p.m. And I'm willing to bet that no member of this committee has read it. I'm willing to bet that it was negotiated in secret amongst and between Republicans, and I'm willing to bet we're about to vote on it without reading it. And I don't know if it happened to reading the bill, but it's relevant to what we're talking about right now. Ms. Edwards pointed this out. Sometimes I feel that I said to my Republican friends, sometimes I think you don't know, the right hand doesn't know what the far right hand is doing. And yesterday in this committee, we reported out an appropriations bill with a rider on it that basically prohibits your bill, the second half of your bill, from being implemented. And I don't know whether someone didn't tell you that we just did that yesterday, and it's going to probably be approved on the House floor. But I'm confused. I mean, Mr. Gibbs, how can you reconcile the rider on yesterday's bill, which prevents the Army Corps from spending any money on implementing new rules, with what we're talking about here today?
Well, Mr. Governor, my understanding is that rider does this, what my bill does, to say stop with this proposed rule, and then we'll have to go back and work at it. And so they might need authorization and go through the process.
I don't think that's what the appropriations bill, I think it just stops it prohibits the funding, if ever.
On implementation
No
going
funding in
forward.
any fiscal year, so.
Well, it prevents the implementation of this rule going forward.
Well, it says any new rules. I mean, that's what the rider said. So I think that perhaps that maybe some of you guys ought to get together and figure out.
Well, I think what Congress is doing, it gives us opportunity to reset the whole process. And that's what that is.
Yeah.
So the appropriation bill puts it on hold.
Again, I get that's a nice kind of convenient answer to the question, but it doesn't reconcile what was approved yesterday in the Rules Committee and what your bill does here today. And sometimes, maybe we ought to take a breath and take some time to do our job a little bit more thoughtfully here. We're bringing appropriations bills up before we even have budget allocations formulated. We have a budget coming up here that's nobody's read. We have appropriations bills that contradict the bills we're bringing up here today. It's all very, very confusing. I don't know, Ms. Edwards, whether you want to comment on it.
The one thing that I would point out, and thank you for reminding us about that rider, because I think you're precisely right, that on the one hand, there's no money to be used to implement the rule, and on the other hand, you want a measure that would allow the promulgation of a new rule, resetting the process. We've actually been resetting the process on this for more than a decade, and in fact, the first Supreme Court decision was 14 years ago, and so I would say that, even for Congress, that's pretty slow rolling. If you look at my amendment, for example, some of the issues that have been raised, and I think that they're legitimate concerns, even though the administrator has appeared before our committees numerous times and has said to us what the rule is and does, and what it doesn't, and the impact on farmland or not, and agricultural processes and not. And so I think we're reading a lot into a rule that doesn't exist, things that don't exist. And indeed, hearing all of those comments, and I take the administrator at her word when she appears before our committees under oath and says that there have been 400 public hearings around the country. I tend to believe that because the consequences of not telling the truth would be so great. And what she has said is that the million comments, 400 hearings, 208 days of a process. The rule has actually now been revised based on those comments in this latest revised rule, which was issued on April 6th. And I don't know if members have had a chance to absorb that, rather than commenting on the rule that had been out there. Mr. McGovern, what I would say to you is that to the extent that any of these concerns are real, then my amendment would actually say, you know what, then it would be the backstop. It would stop it in its place.
Mr. Gibbs, do you have any problem with allowing Ms. Edwards to have her amendment made in order on this bill?
Well, yeah, I think I do. My concern is that when she just said that the EPA has fixed the problems, they have not shared what their fixes are.
Yeah, no, I didn't ask you whether you would vote for it. I just asked you whether you had a problem with her allowing her the right to have a debate and a vote on it on the floor.
I don't know, I guess I can debate anything.
So can we take that as a yes, so when we make the rule that we can say that you think that she ought to have?
I'll leave that up, I'll leave that to the,
And
the good members of the Rules Committee make that
And
decision.
the final thing, Madam Chair, is I'd like to ask unanimous consent to submit for the record the administration statement of policy recommending a veto on this bill.
Thank you very much. I want to try to work it out so that our colleagues can go vote. So I wanted to see, does any Republican member have any questions of our witnesses? Okay. Sorry. Mrs. Slaughter, do you have any questions? I do not. Okay. Sorry, I'm late. That's okay. Well, then you all are excused. We thank you very much for being here, and we will proceed with our next panel then. Thank you very much.
Thank you.
Did you go vote, Mrs. Norton?
We're going to go vote.
Ms. Norton, do you want to go vote, or do you want?
If you guys made a rule,
She can't vote. Oh, that's right. I forgot. Yeah, you'd like to. Good answer. Yeah. Well, then the timing is good here. Oh, I apologize, Mr. Palmer. Have you voted, Mr. Palmer? Okay, I'm sorry, Ms. Norton, if you don't mind, Mr. Palmer was here to speak on the first bill. Stay where you are. But, Mr. Palmer, would you like to make some comments about H.R. 1732?
Yes, thank you, Madam
I
Chairman.
apologize.
That's perfectly okay. My comments in regard to H.R. 1732 are, I would like to offer an amendment to the bill. The amendment would strike Section 3 and read as follows. The Secretary of the Army and the Administrator of the Environmental Protection Agency shall be prohibited from proposing future rules to define the term waters of the United States as used in the Federal Water Pollution Control Act. The point of this is that I think both Democrats and Republicans have something at stake here in respect to the fact that federal agencies, particularly the EPA, have usurped the authority of Congress in terms of lawmaking. I think their proposed rule on the waters of the United States is another example of that, a massive overreach. And it is an opportunity for Congress to regain its authority as the lawmaking body and to restore federalism as was intended with the passage of the Clean Water Act. Congress has determined the best way to protect water quality is by strengthening state-led programs. When I led the Alabama Policy Institute, a state-based think tank in Alabama, every 4 years we published an environmental indicators. We tracked the progress that was being made at the state level and at the national level in terms of air quality, land use, toxic release inventory, and water quality. And at the local level, Alabama's made great progress. There have also been analysis of this proposed rule by other folks, and one in particular that I want to mention is Dr. David Sunding of the University of California, Berkeley. I want to emphasize that he's at the University of California, Berkeley. Sunding documents how the EPA excluded cost, underrepresented jurisdictional areas, used flawed methods to arrive at much lower economic cost of the proposed rule. His report also notes the lack of transparency in the report makes it that makes it difficult to understand or replicate EPA's calculations or examine the agency's assumptions or understand the discrepancy in its results. He concluded that the errors in the EPA's analysis are so extensive as to render it useless for determining the true cost of this proposed rule. I have great regard for Chairman Schuster and the Transportation Infrastructure Committee and appreciate the work they've done on this. But I think Section 3 of that proposed rule, H.R. 1732, simply allows the EPA to continue this process. And taking note of what Dr. Sunding found here, to allow them to continue to take public comment or to provide scientific data or economic analysis. What they've done already indicates that their analysis is not trustworthy. My amendment would not allow the EPA and the Corps a second chance to develop a new rule. Further, the amendment prohibits the Secretary of the Army and the administrators, as I said, from proposing future rules, and it restores congressional authority and the federalism. Mr. Gibbs made a couple of comments that that I think are worth noting by the Rules Committee. He referred to this as a power grab. It's also lawmaking that should probably be done through Congress. And he also indicated, as I did, that the Clean Water Act was cooperative federalism. My point is Congress must retain its authority to make law and not allow EPA or any other federal agency to usurp that authority, and this amendment would force the EPA to respect the authority of Congress and the states. Be happy to take any questions.
Mr. Palmer, thank you very much. I'm delighted that you're here and want you to know that your feedback does matter, and this committee cares very much about your appearance before it. I have no questions. Mrs. Fox.
Thank you, Mr. Chairman. I don't have any questions, but I know of Mr. Palmer's great background in leading the think tank that he led, and I know that whatever he presents to us is going to be something that is well thought out, well reasoned, and I appreciate his being here. And I apologize again that we were moving a little too fast on the first panel. Thank you.
I appreciate that.
Does any other member of the committee have a question? The gentleman from, excuse me, Chairman Cole, you're recognized.
I'd be happy to be called a gentleman. That's nice, actually.
All right.
Not deserved, but very nice.
Sooner,
Thank you.
the sooner.
Well, that's even better.
There you go.
Okay, I just want to thank my friend for his concerns. I want to associate myself with the comments that Mr. Burns made earlier. I've probably heard more about this issue from my constituents, particularly agricultural concerns, and I'm very pleased that Congress is moving toward trying to slow this process down and change it dramatically. And I agree with my friend's point about restoring the authority where it belongs. Should not be a federal concern. It should be addressed by the state and locality. So I appreciate my friend's efforts. I yield back, Mr. Chairman.
Thank you very much. The gentleman from Texas, Dr. Burgess.
Thank you, Mr. Chairman. I just want to thank the gentleman for bringing this to the committee's attention. I hope the committee will look favorably upon this as we go through the amendment process. And thank you for making the time available to us this afternoon. It is an important issue, and as Mr. Cole alluded to, we hear about this, as I'm sure you do too, from our constituents over and over and over again. A sandwich wrapper in a bar ditch should not be a cause of federal action. So thank you for bringing this.
Thank you, Mr. Burgess.
Any other members seek time? Mr. Palmer, thank you very much. I appreciate you taking time, and I'm sorry I was gone for a minute down to go vote. I don't know whether you voted or not. I hope you did. Good. Thank you very much.
Thank you to the committee, and thank you, Mr. Chairman.
Well, you did well enough to get invited back, Mr. Palmer, so I hope you'll take us up on that.
Thank you, sir.
Yes, sir. And if you'll please make sure anything you had in writing that you leave for our awesome stenographers, I'd appreciate it very much. The chairman would now like to close the hearing portion of H.R. 1732 and move to the hearing portion for H.J.Res 43. And I'd like to either allow the gentlewoman her own time or for me to offer some description of what we're doing, which I have not done. Which would the gentlewoman prefer? I don't know whether she's voted or not.
No, Mr. Chairman, I have not voted.
Well, I'm going to intend to let you give your testimony so that we can get through this.
Mr. Chairman, I think I can.
Oh, not on this, excuse me.
I can take all the time
right. It's just a motion on the floor of supporting the decision of the chair. Thank you very much.
Well, I suppose I can take all the time I need since I can't vote.
As always, Eleanor, I'm delighted that you're here. I can't see if you've got the green button pushed on.
I do.
Great, thank you very much. We're delighted that you're here, and anything you have in writing will be entered the record. The gentlewoman's recognized.
Thank you, Mr. Chairman. I always appreciate your courtesy. Actually, I'm not used to being first up on occasion like this, and I'm surprised that no one is here to defend the Republican rule.
Excuse me, ma'am, I am.
Mr. Chairman, normally there's someone sitting beside me because it is their rule, not yours. It's their rule. And I
Yes,
don't
ma'am.
see
I'm
anybody.
just saying I will be in defense of the action today by the Government Reform Committee.
Well, again, I must say that is quite unprecedented since I often appear before this committee. Normally, someone from the committee who requests the rule is here.
Yes, ma'am.
Is here to offer their rationale for being here. And I think, by the way, I'm entitled to that. Mr. Chairman, I hope you will indulge me. Normally, as you may remember, I would summarize my testimony and simply go on and to ask for your questions, but I ask for the opportunity to fully express my outrage that the House would even consider this unprecedented bill. For the first time ever, the House seeks affirmatively to authorize employers, in this case in the District of Columbia, to use religion to discriminate against employees for their private, constitutionally protected reproductive health decisions. Moreover, for the first time since 1991, the House would directly overturn a local District of Columbia law, a gross violation of the right of the 650,000 American citizens who live in the nation's capital to govern their own local affairs. The majority is undeterred in pursuing this ideological exercise, knowing full well that if the House almost never brings such disapproval resolutions to the floor involving the District of Columbia, the chances are even more remote that the Senate will do so. The majority on the Oversight and Government Reform Committee did not even have the courtesy to allow the district's locally elected officials to testify at a hearing to defend their own legislation. Forgive me if I have to state the obvious. I am the only member of this House elected by and accountable to the residents of the District of Columbia. But if this bill goes to the floor, I will not be able to vote on it, but every member of this committee and every member of Congress will. And yet this bill affects only the District of Columbia. My Republican colleagues cite freedom of religion, a freedom I revere, a freedom that I myself have defended as a lawyer. But in this case, it means the freedom of any employer in the District of Columbia to discriminate against any employee because the employer learns of the personal, constitutionally protected reproductive choices employees make in their private capacity, even though these same employees are ready and willing to carry out the employer's policies and practices on the job, whatever those practices are. This is not freedom of religion, Mr. Chairman. This is freedom to discriminate. The federal courts have been vigilant to contain religious objection because our Constitution must accommodate other rights simultaneously, including the right to be free from discrimination and the right to privacy. The elected D.C. Council unanimously passed, and the elected mayor signed the Reproductive Health Non-Discrimination Amendment Act to prohibit employers in D.C. from making employment decisions based on reproductive health decisions of employees, their spouses, or dependents after reports of employees being fired for such decisions. Why didn't the House hold a hearing on this bill? Perhaps they did not want witnesses to testify about examples that now come from across the country of employment discrimination based on reproductive health decisions. H.Res 43 permits employers to fire a woman for having an abortion due to rape, fire a man for using condoms, reduce the salary of a parent for buying birth control pills for his or her child, or decline to fire a woman for using in vitro fertilization to become pregnant. The Reproductive Health Non-Discrimination Act is constitutional and legal. Under the U.S. Constitution, laws may limit religious exercise if they are neutral, generally applicable, and rationally related to legitimate government interest. The Reproductive Health Non-Discrimination Amendment Act applies to all D.C. employers, does not target religion, and promotes equal workplace equality. Under the Federal Religious Freedom Restoration Act, which also applies to the district, a law may indeed substantially burden religious exercise if it furthers a compelling governmental interest in the least restrictive means. Even if the Reproductive Health Non-Discrimination Amendment Act substantially burdens religious exercise, D.C. has met the compelling interest standard of the statute because D.C. has a compelling interest in providing equal employment opportunities, and courts have held that non-discrimination laws like the Reproductive Health Non-Discrimination Amendment Act are the least restrictive means to further a compelling interest. Religious liberty is protected under the D.C. Reproductive Health Non-Discrimination Amendment Act. Employers may continue to make employment decisions based on their religious and other beliefs, including political beliefs, and their employees must be willing to carry out the employer's mission. What they cannot do, what employers cannot do, is hire and fire based on private, personal conduct, off the job at that. The Reproductive Health Non-Discrimination Amendment Act is subject to constitutional and statutory religious exceptions to discrimination laws. The constitutional ministerial exception does permit religious employers to make employment decisions for ministers and ministerial employees for any reason whatsoever. DC's employment non-discrimination law provides exceptions for religious and political organizations to make employment decisions based on religion and based on political views. The DC exemption says that nothing in the act shall prohibit, and here I'm quoting from the act, religious and political organizations from limiting employment or admission to or giving preference to persons of the same religion or political persuasion as is calculated by the organization to promote the religious or political principles for which that organization, is established or maintained. Title VII of the 1964 Civil Rights Act, which I administered as chair of the Equal Employment Opportunity Commission, and I also administered religious exemptions under that act, allows religious employers to make employment decisions based on religion. The Reproductive Health Non-Discrimination Amendment Act, the DC law, does not require employers to provide any type of health insurance to employees, including abortion or contraception. Instead, it requires employees to be treated equally for employment-related purposes. Both the text and the legislative history of the DC Reproductive Health Non-Discrimination Act makes that clear. Nevertheless, to be absolutely clear, after members of Congress expressed concerns that the bill requires insurance coverage, the DC Council, in order to eliminate any doubt, however remote, passed a new version of the Reproductive Health Non-Discrimination Amendment Act that expressly states that it shall not be construed to require an employer to provide insurance coverage related to a reproductive health decision. This provision is now in effect, but due to the Byzantine procedures Congress imposes on the District of Columbia in the Home Rule Act, the bill cannot become final until the end of the congressional review period. How pitiful. H.Res. 4.3 is an abuse of congressional authority over the District of Columbia. In 1973, Congress passed the Home Rule Act to give the district the authority to legislate on local matters with a few enumerated exceptions and to relieve, quote, Congress of the burden of legislating upon essentially local matters. DC employment and reproductive health laws are not among those exceptions. I ask my Republican colleagues to live up to their fiscal year 2016 budget. That budget says, and here I am quoting, America is a diverse nation. Our cities, states, and local communities are best equipped and naturally inclined to develop solutions that will serve their populations. But far too often, local leaders are limited by numerous federal dictates, end quote. How is today's action consistent with that language in the Republican budget, Mr. Chairman? I urge the majority to live up to its professed principles of local control, of local affairs, federalism, and limited government. And I thank you, Mr. Chairman.
Yes, ma'am. Thank you very much. By the way, successful rain dance has a lot to do with timing. You expressed exactly your desire for a member of the committee of jurisdiction to appear and to come and defend what they're doing. And in fact, that's what's happened. I was caught off guard a little bit, but the gentleman, Congressman from North Carolina, Mr. Meadows, is doing exactly that. So I'd like to call up Mr. Meadows at this time, gentleman who would wish to be recognized on this matter. Mr. Meadows, I'm delighted that you're here. You have a little bit of help with Mrs. Fox at least. You might need some help today, may not, but we're delighted that you're here, and the gentleman's now recognized.
Thank you, Mr. Chairman, and I thank the Vice Chair, Ms. Fox, for her eloquent words. I thank all the committee members, and I rise today really to address some of the issues with regards to my good friend, the delegate from D.C., and I say dear friend in the sincerest of ways, because as she knows, we have been working very diligently to try to solve this issue so that we would not be here today. And I think there's a lot of what has been reported on what this bill is and what it is not, and does it recognize home rule of D.C. and does it not? And the delegate knows that having worked side by a mayor for many, many years, I know the difficulties of local jurisdiction and the ability to run a city, and certainly the mayor has embarked on a very difficult task along with Eleanor
my dear friend. I say that as a preface because some of what we are discussing here today really has nothing to do with home rule, and it has nothing to do with some of the talking points that have been put out there with regards to either contraception or abortion. It has everything to do with religious liberty. And when we look at the foundation of our country, in this very rotunda of this very building, is a portrait of a gentleman by the name of William Brewster, who had an open Bible here, who came for religious freedom, who came here to America to make sure that they had the right to exercise those religious freedoms. That person is my 11th great-grandfather. And when we look at that, it is important, not just for me and not just for Eleanor, but for all Americans, that they know that those religious freedoms that our founding fathers not only put there to uphold and protect and defend, that men and women's blood have been shed in defense of those same freedoms. That what we must do today is that when a law, in this particular law, I'll be very candid, all we're asking for is a broader ministerial exception. Because of the religious liberty aspects of this, the delegate, and as well as the city council and mayor, knows this very clearly, that if we can broaden that ministerial exception so that we can protect the free exercise of religion. You know, we've got a number of Catholic universities here, a number of Catholic schools, churches, and the Supreme Court, Mr. Chairman, has already ruled on this. You know, if we look at Nathan Tabor versus EEOC in 2012, they went beyond this to say that it is not just the pastor or the minister or the priest. It is all of those that work there that have a ministerial obligation and should be protected by this. That's all we're asking for, Mr. Chairman, very simply. I'm hopeful and still hopeful that we can find some kind of an agreement to make sure that the religious liberties can be protected. I would prefer to not be here today. I think most of us would prefer to not be here because we do recognize local government is imperative. But when you allow local governments to set federal policy, Mr. Chairman, it is the wrong thing. It would be like asking the city of Lenore to pass a law that would do away with the Clean Air Act. Would we recognize that if it were setting federal precedent? I would venture to say that everyone in this chamber would agree that that would not be appropriate. And so here we are today defending this particular issue, really, and I don't have a Catholic background, but for all of those who do, we need to make sure that we stand up and protect that, because the message we're sending today, if we don't, is very loud and clear. It's okay for you to have your schools and support DC children, but it's not okay for you to have strong opinions in terms of what you believe. And that, Mr. Chairman, is not the right way for us to go about this. And so I'm here today. We'll be glad to answer any questions that this committee may have or any that the delegate may have. I think she knows that we're desperately trying to work in a bipartisan way to solve this particular issue. I thank you. I yield back.
Mr. Meadows, thank you very much as the subcommittee chairman on government operations for the Government Reform and Oversight Committee. I can tell that not only have you come to this committee with the greatest of intent to clear the air, but also to make sure what I believe is a reasonable attempt that you, as well as the young chairman of the committee, to work with those that disagree with you, with the knowledge that your action is a reaction to what you believe is the expressed law of the land, as well as the intent within law to protect those that work within those organizations. And I find your arguments very compelling, and quite honestly, your arguments would be better than mine had I offered a representation, because I was aware of the Supreme Court's action, but unaware of all the work that you personally had been doing in this regard. I respect and appreciate you, and I have no questions. Mrs. Fox.
Mr. Chairman, could I
Excuse me
respond?
just a moment, please. Does your gentlewoman seek time?
Yeah, I would seek time.
Gentlewoman's recognized.
First of all, I want to say how much I appreciate my good friend Mark Meadows. He has worked I won't say religiously, that's probably not the right. He has worked very hard to try to come to some reconciliation. Mark, I think it's very funny that you mentioned the Clean Water Act, because somebody was here just now trying to pretty much do what you said, dispose of it altogether. The answer to that, of course, would be that a state or locality has to abide by federal law, and that is federal law. So no local jurisdiction could do that, and we don't think that the district is trying to do what local jurisdictions cannot do as well. First, I want to emphasize, as I said in my testimony, there's an absolute ministerial exception. Now, I want to indicate how far the Supreme Court has gone, because the Supreme Court, recognizing that it's always called upon to reconcile constitutional rights that might bump up against one another, had a case not long ago where a teacher in a religious organization had been in a school, taught in a religious school, had been fired. Normally, under the equal employment laws, a teacher in a religious school is entitled to the protection of the equal employment laws. She prevailed. She prevailed because she taught religion. That's how narrow the Supreme Court has construed the religious objection. Here you would have an employer, for example, in, I don't know, CSX Railroad downtown, who had a religious objection to some form of private reproductive choice, who using his non-religiously, in his non-religiously based organization, could fire someone simply because a organization has a religious purpose does not make it a religious organization. Those organizations are subject to Title VII of the 1964 Civil Rights Act, and the courts have held that over and over again. But their ministerial employees are treated within the ministerial exception. DC has been very careful to observe the ministerial exception here. That is the reason that I think, while offered in good faith, that the gentleman's objection is not in order. A Catholic school, for example, if you taught religion in the Catholic school, you're exempt. But if you're a teacher in that Catholic school, you're not exempt if you teach chemistry or if you teach history. That's how the courts have construed these rights when they collide with one another.
Gentleman, evidently seeks time to offer a clarification to this gentleman.
If I may clarify, Mr. Chairman.
Thank you, sir.
The case that the gentlelady is referring to is indeed the one that I referred to. It says the 2012 case was a unanimous decision. And in that ruling, Chief Justice Roberts, but there was concurring opinions by other justices, would indicate that it was not indeed just because she taught religion. She taught other subjects as well. And in terms of prevailing, they were very clear that the message of that particular Catholic, that particular one was Lutheran, that particular Lutheran institution was not confined to just those who teach religion or ministerial. And that's precisely my point, is when you have this, it would be like Eleanor having someone in her staff who said that they did not believe in D.C. statehood. Would you expect the gentlelady from D.C. to continue to employ someone who was undermining her at every single case?
No.
I know you wouldn't.
No, and the D.C. law does not. The D.C. law does not require that she be kept.
Perhaps
Oh no, that was a hypothetical.
That's a hypothetical.
But in this,
But it's on point.
I don't think he presumed for you.
No, I was not. I would just, because you and I know how passionate you are about that particular issue. And so here's what I am saying is, with this particular case, and we can, if we broaden the scope of this, because the narrow scope of where this ministerial exception is right now really confines it to those that are either in ministry or of that particular same faith, if you want to refer to this. And the gentleman, the council that's referring to her, we've had a number of discussions on this particular thing. We have proposed language, Mr. Chairman, that would be satisfactory to the committee, satisfactory to most of those that would be affected by this particular rule, that would expand that particular provision. To date, we have not got an acceptance by either the DC Council or the mayor or the minorities council, but in doing that, very limited language would actually make sure that we're not violating the Constitution of this great United States. Mr. Chairman, I yield back.
Ms. Meadows, thank you very much. Mrs. Fox.
Thank you, Mr. Chairman. I really appreciate Mr. Meadows being here and giving us a balanced view of the way you and others have tried to avoid our being here today. It really is unfortunate that the DC Council and others have not taken us up on our offer to keep us from having to be here today. So I want to thank you for your efforts and say that I support very much this resolution and look forward to our being able to get it passed. I yield back, Mr. Chairman.
Thank you very much, Mrs. Fox. Mrs. Slaughter.
Thank you, Mr. Chairman. Mr. Meadows, very nice to see you. My father's North Carolinian, so I've got cousins all over. It's very intimate.
Right.
Yeah, and Elder, I never fail to be impressed with your knowledge of the law. It's really a pleasure to have you here today. We really don't need to be here today. I couldn't agree with you more on that statement. This is really, since you're talking about non-discrimination, I assume that you believe in discrimination to start with. But let me, if you're really only concerned about the ministerial thing, I think that this explains quite well that shouldn't be a problem for you. Let me read from the minority views. We strongly oppose H.J.Res 43. The bill would sanction employment discrimination in the District of Columbia under the guise of religious liberty. The bill would permit employers to make employment decisions based on private.
Would the lady yield for just a moment?
I will.
Thank you for that. I appreciate it. I want to make something clear because I'm afraid it came across wrong.
Okay.
Because, and then if it wasn't, then we'll clarify.
Right.
But by saying that the gentleman talking about non-discrimination must believe in discrimination, is that what you really meant?
What I'm saying, if you're saying that a bill that does non-discrimination and you want to change it, and I think it's pretty plain in here that there is no discrimination in the ministerial part. I think that, do you agree with that, Ms. Norton? That's pretty well covered, then we don't need to be here today, is the main thrust of what I
Well,
want
it's
to
amazing to me we have to be here to defend religious liberties, but I think it's very concerning that if you say that the gentleman, because he's talking about non-discrimination, it believes in discrimination, that's unfair to the witness, and I just couldn't let that sit by. I'll let the gentleman lady continue.
Thank
but
you.
I wanted it for the record that this gentleman right here is of utmost integrity and would not believe the discrimination of anyone, and I just can't let that go any further.
Well,
I gotta yield back to the lady.
Thank you. I'd like to continue because let me tell you the discrimination that you will create if you do this. The bill would permit employers, I think, Mr. Collins, I want you to hear this as well, would permit employers to make employment decisions based on the private, constitutionally protected reproductive health decisions of employees, their spouses, and their dependents. I consider that discrimination, Mr. Collins. The bill is also undemocratic. It would overturn the will of the 650,000 district residents expressed in legislation passed by their legislature and signed by their elected mayor. Further facts that it is an assault on American citizens' reproductive health rights and the District of Columbia's right to govern itself with its own tax money, and it, in fact, as long as it's not unconstitutional. It contradicts the Republicans' professed support for local control and would allow employment discrimination in the district. The D.C. law is consistent with the Free Exercise Clause, which is the one you're worried about, of the U.S. Constitution and the Religious Freedom Restoration Act. It would allow employees to make employment decisions on their private, constitutionally protected reproductive health decisions of employees, their spouses and children. I know I've said that already, but I think it's important to make that very clear. For example, it would allow an employer to fire an employee because she had an abortion after being raped. It would demote an employee because she used birth control pills or her spouse used condoms, or pay an employee less because her daughter became pregnant out of wedlock. I consider that all discrimination. Everyone should have the ability to make the private health decisions, including whether, when, and how to start a family, without the fear of losing their job or facing retribution. I will leave it with that because I know my colleagues will have a great deal to say about it as well. I don't think that, you know, this may satisfy some need here. I don't believe the Senate will take this up because I think they're getting tired of beating up on women. And certainly I know that the president would not sign it. So once again, we spin our wheels up here and spin our wheels and go around and around. I'd like to ask unanimous consent to put into the record the article from the Washington Post entitled "Republicans Again Appeal to Theocracy." Also, the statement fact sheet that I just quoted from.
That objection will be in the record.
Thank you very much.
I would like to.
And I yield back.
Gentlewoman yields back her time. Thank you very much. I'd like to, if I can, offer some bit of my personal plea, and that is that I recognize that we are dealing with a lot of sensitive issues here, some personal, some professional, some by representation. I have always want to try to allow any member of this body that respectfully presents themselves to us, including the members on this committee, I try and allow them a latitude that I consider to be most important and that I respect. What I would like for us to, if we can, is perhaps, and I'm not going to say Mr. Meadows started it, I'm not going to say I started it, I'm not going to say anybody started it, but where we can not second guess each other's intentions about the way we might think or what we might represent. I think it's most important that we be able to discuss with each other, even the most sensitive and difficult things. I hope that I will continue to allow people to come up here, and even when others may or may not be as open to hearing some of the ideas they've got, I hope I'm open to them. But I would like to ask that we be very careful not to impugn a person's motive or to place upon them a personal observation. I think it's best if we do that. Now, if you want to proceed at your own peril, I encourage us to do that. I'm not trying to admonish. I'm not trying to discourage anybody. I'm trying to put it in what I believe is a good boundary that we can effectively get our job done and be disagreeable, but not have to make it personal at all. Gentlewoman, seek time.
I do.
Gentlewoman's
I
recognized.
certainly not intend to be impertinent or personal or unpleasant, but simply to point out if indeed, Mr. Meadows, and I believe you when you tell me that your interest is in that ministerial portion of it, that you have nothing to worry about. And I wanted to make that point.
I appreciate that. Does anyone else have a comment that's on the committee about what your chairman has said? Thank you very much, gentleman from, does the gentleman seek time? You want to jump into this one?
Just very quick.
The gentleman from North Carolina is seeking time.
I thank the chairman for
I
reminding us,
will give-
because this is a deliberative body and not one of accusations. And so certainly if there is anything that has been construed in any way on my behalf to be anything other than show the utmost respect for my dear friend and colleague here, she knows that I'm going to continue, regardless of what happens here today, to work with her to make sure that the folks of D.C. have their voice. And so I thank the gentleman for reminding me, and I yield back.
Yes, sir, and let me say this. I think that the gentlewoman did clarify that straight up in her comments, that we allowed her time to state. Now, let me say one more thing. I know where you're from, and I know people that expect you to be good and to your word, and I expect you to do that, and I appreciate it very much because that's what I think about you as a young man in this body, and I appreciate it very much. Gentleman from Oklahoma, the young chairman, Mr. Sooner, is recognized.
Thank you very much, Mr. Chairman. I'm not, we'll let that pass this time, but that's fine. That's great. That's always an honor to be called. I just want to, I don't have any questions, but I want to just quickly thank both the witnesses for the testimony. And I know this is a difficult issue and a contentious issue, but I admire both of you, frankly, for the way in which you handle yourself, your professionalism, your obvious respect for one another. And I just think it's an example of how Congress ought to work even in a difficult issue. And you both always carry yourself that way personally and professionally. So it's always a pleasure to have either of you in front of this committee. With that, I yield back, Mr. Chairman.
Yes, sir. I appreciate the gentleman's comments that are meant on both sides to appreciate and respect our witnesses. Gentleman from Massachusetts recognized.
Yeah, well, I too appreciate the fact that this is a difficult issue and an emotional one, but I'm always amazed at how the majority in this Congress trample on the rights and the will of the people of the District of Columbia. And I mean, and it's not just on this issue. I mean, whether it's on guns or I go right down the list, I mean, the majority tends to impose their viewpoints on the people of this great capital, where where in this case, I mean, you had an elected legislative body in the city, make a determination that I think, quite frankly, we ought to respect. And I don't believe, and I do agree with Ms. Slaughter that I think H.J.Res 43 would allow discrimination in the nation's capital, and that bothers me greatly. But I'm just always stunned that we disregard what the people who live here want, and I regret that very much. And so I yield back my time.
Gentleman yields back his time. Thank you very much. Does any Republican seek time? Mr. Polis, you're recognized.
Well, thank you. I really want to second what the gentleman from Massachusetts said. I mean, whenever we're here, no matter what the issue is, talking about it, it's awkward because I'm not from D.C. I don't live here, and I would think it would be just as awkward if people were making decisions for my constituents back home in Colorado and trying to go against what our state legislature and our governor do. And I hope that we take this occasion to join in supporting statehood for Washington, D.C., because until that happens, we're going to always be in the awkward position of imposing our will, whatever it is, whether it's liberal or conservative, whether it's pro-choice or anti-choice, whatever it is, you're imposing it on American citizens who don't have, and you're overriding what they themselves do. I would be less restrained than Ms. Norton if people were doing that to Colorado. I don't know what I would do if everybody was trying to overrule our state legislature and our governor. The answer is obvious. We should admit D.C. as a state and then treat them the same way we treat other states. And so I think this testimony here today just underscores that point, and hopefully we can be voting soon on D.C. statehood bill, which I'm proud to co-sponsor, and I yield back the balance of my time.
Jimmy yields back his time. I want to thank both of you very much. Yes, ma'am. Yes, ma'am.
First, I want to say that Mr. Meadows has gone out of his way. When we're in committee meetings on another subject, he'll come up and try a new hypothetical. He recognizes that we have conflicting rights here, and he wants to make sure that we don't override one or the other. And I want to say how much I appreciate that. His use of the ministerial exception, of course, would broaden it so substantially that there would be nothing left of the equal opportunity laws. And that's why not only do I have to oppose it, I don't believe any federal court would allow it. I do want to offer an example, since we have heard it said that if someone, for example, to take one of the most sensitive issues always in this Congress, let's say we have an organization who wants to make sure that abortion is no longer possible in the United States, that employer can say, I need to know your views, because you've got to carry out this organization's mission to oppose abortion in every way. You can inquire of that employee or candidate about that, but you cannot ask that employee, by the way, what form of reproduction do you use, reproduction prevention do you use, if any? You can't answer. You can't ask that. Not in America. That's what we're getting at. We're not trying to control the views of the employer to make sure he's got on his staff somebody who will carry out the mission of that organization in each and every way. I have great respect for freedom of religion. I have great respect for people's right to express their opposing views. As an ACLU attorney, I had the opportunity to represent people who were avowed racists and to argue that they should have the same First Amendment rights as anybody else. And I won that case in the Supreme Court of the United States, 8-0. So the notion of expressing your views and making sure that anybody you hire is going to carry out those views is a First Amendment right that I respect, and I believe that employer has every bit that right as I do. I just wanted to clarify that so I would not be misunderstood, not because my friend was alleging that. Thank you very much, Mr. Chairman, for your courtesies.
Yes, ma'am. I want to thank both of you for taking time to come up here. Mr. Meadows, you appeared perfectly. Great timing. I appreciate your demeanor. I appreciate your professionalism, and mostly I appreciate both of you in dealing with each other straight up and fairly. And I want to thank you for taking time. Thank you very much. Thank you, Mr. Chairman. By the way, if you'll please leave anything you have in writing for our awesome stenographers. We appreciate it. The chair now notices that the young man, Mr. Tom Kahn, has appeared, which is an indication that we are going to go to budget time. Mr. Kahn, we're delighted that you're helping Mr. Yarmouth today. I'd like to call on our next panel, including the young chairman of the Budget Committee, the gentleman from Georgia, Dr. Price, and also Mr. Yarmouth. Mr. Yarmouth, we're delighted that you're with us today. Mr. Price kind of cheated. He knows what he's doing. He's been up here a bunch, so I urge some caution. He's got a home field advantage here. We're delighted both of you are here. You're bringing to us a package that's signed by the United States Senate and the House conference report, and I'm delighted. Gentleman from Georgia is recognized.
Thank you, Mr. Chairman. Thanks to the committee members. Good afternoon, one and all. It's a great privilege to be able to come before you today and announce an agreement on behalf of the House and Senate Budget Conference. Passing a budget, Mr. Chairman, is one of the Congress's core legislative responsibilities. More importantly, we have a responsibility to hardworking American families to be good stewards of their tax dollars. When we fail to budget, we fail to meet that responsibility. So I appreciate the work of all of my colleagues on the committee and throughout the House in making sure that we're here today to do the right thing with this joint House-Senate balanced budget agreement. Like the House and Senate budget proposals that passed last month in each chamber, this conference agreement balances within a 10-year period of time, and it does so without raising taxes. Because it's neither fair nor sound economic policy to take more money out of the pockets of the American people. This budget plan would reduce spending by more than $5 trillion over the next 10 years through common sense reforms that will make Washington more efficient and effective and accountable. At the same time, we prioritize investments in key areas like our national defense. This proposal ensures that our men and women standing in harm's way have more resources to be able to complete their mission and defend America and our interests around the world. It saves and strengthens vital programs like Medicare and Medicaid. These programs, Mr. Chairman, are currently on an unsustainable and failing path. They will fail if nothing is done. They'll fail to deliver the promises that have been made to the American people in these programs. That's unacceptable. To sit back, as some seem to suggest is the appropriate thing to do, and do nothing and let our most vulnerable citizens and our seniors suffer from future cuts to their health care is unconscionable. We can do something about it. We must do something to strengthen these programs, and we do in this budget. At the same time, by forcing Washington to live within its means, we can put the government on a path to paying off its debt and avoid a future where interest payments crowd out critical investments in national security and economic security or the nation's infrastructure. By getting spending under control and our debt on a downward trajectory, we can lay a solid foundation to a healthier economy. Getting our fiscal house in order will mean more opportunities for more American entrepreneurs and job creators and allowing them to thrive. Folks who are struggling today will see their wages increase and a brighter, more secure future for themselves and for their children. As I'm sure you're all aware, over the last few years, the Congressional Budget Office has consistently revised their economic growth projections down from 3.0 to 2.9 to 2.5 and now 2.3 over the next 10 years. In other words, the Obama administration's policies have chronically overpromised and underdelivered. Our budget would turn the page, ending this new normal of slow economic growth and stagnant wages, and move the nation in a new and a positive direction. Among the actions that we will take is a complete repeal of Obamacare, including the taxes, the spending, the mandates, the regulations, and the regulators, like the Independent Payment Advisory Board. We would get rid of this attack on the doctor-patient relationship and pave the way for patient-centered reforms, where patients and families and doctors are making medical decisions, not Washington, D.C. Reforms that give folks access to higher quality and more affordable choices. Additionally, we would protect Medicare from the Obamacare raid while paving the way for reforms to that vital program so that we can save and strengthen and preserve that program for today's seniors and tomorrow's retirees. We believe Obamacare is harming patients, medical providers, and job creators. It's stealing resources from our seniors on Medicare, and we ought to do everything in our power to get rid of it. That's why this joint budget agreement directs reconciliation instructions to those committees in both the House and the Senate that have jurisdiction over health care. Once the House and the Senate have adopted this conference agreement, we will be able to proceed with that reconciliation process. At the end of the day, we must not lose sight of the fact that this debate we're having is not just about the budget process. It's a debate about what kind of future we want to leave our kids and our grandkids. Whether we continue down the road of subpar economic growth and fewer jobs and less opportunity or not, or whether we make responsible decisions today, make some positive reforms that will ensure that we live in a safer, more secure nation that can support and nurture the hopes and dreams of America's generations today and those to come. With responsible leadership, America's best days will always be ahead. That's what this budget represents, a down payment on the limitless possibilities that will exist if we seize this moment and embrace our responsibility to American taxpayers, to our seniors, to our military men and women, to job creators and entrepreneurs, to the folks who get up every single day, go to work and earn a living, and to those who get up every single day and look for a job so that they may be able to provide for themselves and for their family. Mr. Chairman, I'm enthusiastic about the opportunity to bring this conference agreement forward, and I appreciate the opportunity to answer any questions that you all may have. Yield back.
Thank you, Mr. Chairman. I appreciate the opportunity. Ranking Member Slaughter, too, and members of the committee, I appreciate the opportunity to present the Democratic perspective of the Budget Committee members on this conference agreement. The Republican conference agreement on the fiscal year 2016 budget resolution ensures that middle-class Americans and those striving to join the middle class will work harder and get less. It is a dangerous recipe for national decline. It makes it harder to buy a home and pay for college, causes millions of struggling Americans to fall deeper into poverty, jeopardizes the health of millions more, and makes it harder to have a secure retirement. The conference agreement does nothing to help those Americans looking for jobs, does nothing to boost the paychecks of working Americans. Despite working harder than ever, American wages have stagnated for decades as the economic gains from their hard work have increasingly flowed to those at the highest income levels. The rich get richer, the poor get poorer. This conference agreement, instead of reversing that trend, makes it worse. We believe it paves the way for tax cuts for the wealthiest few while raising taxes on the middle class and hardworking families. The conference agreement deliberately ignores the growing mountain of evidence that trickle-down economics has been a miserable failure, having boosted nothing but budget deficits and the incomes of the already wealthy. We had the worst economic crisis since the Great Depression, and now, even as employment has rebounded the last 5 years, Americans working those jobs are working harder for less. People who had money to begin with have never done better, while the middle class continues to shrink. It's time for this government to prioritize struggling families, to value not only those who have wealth, but Americans who are still aspiring simply for financial security and who are willing to work for it. This budget disinvests in America by slashing the nation's commitment to education, research, infrastructure, and other crucial drivers of economic prosperity. At the same time, it refuses to cut a single special interest tax break in order to reduce the deficit. And its claim of reaching balance is built on a shaky foundation of huge gimmicks. Observers across the political spectrum, from liberal to conservative, have all noted that this budget is full of financing gimmicks. And the most blatant one is calling for the repeal of Obamacare, Affordable Care Act, keeping all of the revenues from the Affordable Care Act and all of the savings, but repealing the law. That simply doesn't work. All in all, just like the separate House and Senate-passed versions of the budget, the conference agreement rigs the rules to favor the wealthy and special interests at the expense of everyone else. I want to make one more comment about the Affordable Care repeal efforts here. There is a certain issue about repealing the health care and taking health care away from 16.5 million people now, a number which will continue to grow. But there's also the impact that repealing the Affordable Care Act has on other parts of our national economy. And just as an example, the Deloitte Professional Services Organization just did an analysis of Kentucky's Connect, that's what we call our Affordable Care Act exchange and program. We've insured more than 500,000 people as a result of the Affordable Care Act. That's out of a population of 4.4 million. But the Deloitte firm analyzed what the impact of the Affordable Care Act is going to be on Kentucky for the next 6 years. It said the Affordable Care Act will result in $30 billion worth of increased economic activity in the state over the next 6 years, will add 44,000 jobs in the state, and will have a net positive impact on Kentucky's state budget of $850 million. If you multiply that impact across the entire country, you're talking about doing incredible damage to, and losing an opportunity, more importantly, to really get this economy moving. The funding levels in this measure don't meet our moral obligation to move our country forward and help the American people. Not only do they fail to meet the needs of the people we represent, it fails to meet a basic standard of honest budgeting. At every turn, this measure misses the mark in fulfilling our obligation to properly fund the necessary programs and efforts that will allow us to continue our economic recovery. So I thank you for the opportunity to present that perspective, and I look forward to questions.
I appreciate both you and Chairman Price being here, making yourself available. And I'm going to wait on my questions till the very end. I've got several questions that I would like to pose to both of you, but to the chairman of the committee in particular about what this is, what its impact will be, and what the law and the president, because I don't believe a signature is required on this, and what it will mean on a moving forward basis, since it's not going to be the law, but will simply be the guiding post for us. And I'd like to yield, once again, I'll come back at the very end. I'd like to now defer to the gentlewoman from North Carolina, Mrs. Fox.
Thank you, Mr. Chairman. I thank our colleagues for being here, and want particularly to compliment Chairman Price on this historic achievement of the conference report. I'm not going to repeat all of the things that he's talked about in terms of where we've come and what this means to us. I am grateful that some language I suggested to go into the budget survived the conference report, which I think makes this a very strong report, and have no questions. So I yield back my time and thank you both for your work.
Mrs. Slaughter?
Thank you, Madam Chair. Look, I have not had an opportunity to even look at this. I've been up here for the hour it's been available, and I have no idea what to say, but I would like to ask unanimous consent to put the minority leader's comments in the record, if I may.
Without objection.
If it, indeed, what it does to start out with is you're going to repeal Obamacare, words fail me, Dr. Price. I know we voted on it 57 times to kill it and failed to do it every time. So you're going to do it this way, right? But you're going to keep the revenues according to what Mr. Yarmouth said?
Well,
Could you give me some idea of how that works? What you're going to do in the budget? Once the budget's passed, Obamacare is dead. Is that it?
No, as you know, Ranking Member, the budget isn't a law. The
Right, I
president
understand
doesn't
that.
sign it. What we
But we
do
need-
what we do in the budget is two basic things. One is we set the spending limits for the Appropriations Committee for the next fiscal year, FY16, and then lay out a path for the next 10
That
years.
assumes the Obamacare is gone.
And it directs the committees of jurisdiction to move in the direction of repealing Obamacare and accepts the savings that would occur under the repeal.
What about the savings that would occur by leaving it, but what are occurring now? The savings, I'm very much impressed with what Mr. Yarmouth said about the study in Kentucky.
Well, the
$30 billion, you said, over 6 years?
The savings that we identify in the repeal of Obamacare is almost $2 trillion, and that's not us saying that. That's the Congressional Budget Office that says if that law were to be repealed and replaced with appropriate patient-centered health care, that the savings to the federal government would be about $2 trillion, which is sizable, and we believe that the law itself is not only hurting the economy, but hurting the health of the American people.
So it would take us back to the great example of McAllen, Texas, where one hospital in a small town in Texas, per capita, got more Medicare money than anybody else in the United States because apparently everybody in McAllen had an MRI or a CAT scan every few days. Anyway, they were using an awful lot of tests to up their reimbursement.
No, it wouldn't do that. It would move us forward in the direction.
I understand. I know that Obamacare took care of that, but once it's repealed, do you plan to do something on that order?
Move us forward in the direction of what we call patient-centered health care.
Away from fee-for-service?
Where patients and families and doctors are making medical decisions, not the federal government. And it's an
Well,
exciting opportunity.
I'm sure patients and doctors made the decision in McAllen. What this would require is a change from fee-for-service to outcomes. Will that be part of your plan?
As you know, the Budget Committee isn't responsible for identifying the specific legislation.
I know
be
that, but
adopted.
since you
The
wrote
Ways
this,
and
you
Means
must have had
Committee and
something in mind on that.
Absolutely. I have a bill, H.R. 2300 from the last Congress, that would put in place these positive patient-centered reforms that moves us in a direction of a healthcare system that is responsive to patients and families and doctors and not the federal government.
Well, again, I haven't seen it, so I really can't comment on it. I'll wait for later.
Thank you, Mrs. Slaughter. Chairman Cole?
Thank you very much. I feel like I'm very privileged today because I have effectively two chairmen here today. I get to serve as my friend Mr. Yarmouth does on the Budget Committee with my friend Mr. Price, and I'm very proud to participate. I get to serve as a proud member of the Bourbon Caucus, which Mr. Yarmouth chairs with great distinction. I must say I participate fully in both bodies. Probably the work is a little more momentous in yours, Chairman Price, but it's probably a little bit more enjoyable in Chairman Yarmouth. So it's good to have both of you. You really are two of the members I respect. I do know this very well, having sat on the Budget Committee, and the Chairman was kind enough to keep certainly our side of the aisle very well informed during the budget conference process. And I just want to note for the record, obviously, we disagree in a partisan sense. I've never voted for a Democratic budget. I don't think any Democrat has ever voted for a Republican budget. This is, as it should be, the governing vision of each party. And so when you're in the majority, you have the privilege of moving that across the floor. But it's not easy to move across the floor. And in many cases, it has not happened. It's the first time we've had an agreement like this with the United States since 2009. And Mr. Price, or Chairman Price, I just want to congratulate you. I think it is a really remarkable achievement. Again, whatever our differences are, this is where you begin to actually be able to legislate from a vision with a plan. It will certainly impact what we do in appropriations. It always does. But I think it confronts some of the real problems that we have on the entitlement size of the budget, and that takes considerable courage. And I think we've shown that. Now, our friends would have a different vision, and at some point, I hope we can sit down, just as we did over SGR, which involved a measure of entitlement reform, and come to a good agreement where we can. But you have to start by laying something out, and this is our opening position in that process. And I couldn't be prouder of the manner in which you brought us together, moved us through the process, and frankly, clearly worked well across the rotunda with the Senate, which is, our friends would agree with me on this point, is a hard thing to do. They've had their challenges doing that when they were in the majority. So this is no small feat of legislative craftsmanship, quite the opposite. It's just really well done. And you did it in a way that, again, was very true to our principles, what we think ought to happen in terms of taxation and spending and trying to get the country back on a fiscally responsible course. So, again, both of you I regard as really dear and good friends and very productive members. And Mr. Yarmus, a worthy adversary, but I will promise you, Mr. Price, at the end of the day, he's the kind of guy you'd like to sit down and have a bourbon with. Because he's always full of insight and wisdom as well. So again, you're both to be commended, but particularly you, Mr. Chairman, for having accomplished this. It's quite a tribute to you. Thank you. Yield back.
Thank you. Mr. McGovern.
Thank you, Madam Chair. You know, I similar to what the ranking member said, I can't really comment on a lot of the details of the budget because we just got it, and it was a budget negotiated with Republicans, negotiating with Republicans. So, you know, so I would first criticize the process in which this is being presented to the full House, a 100-page bill that, you know, during the last go-around of votes, I was trying to get answers from the minority committee staff about what was in this bill and what wasn't in the bill, and they were still trying to go through all this. It's really kind of a lousy way to do business. But anyway, you're in charge and you can do whatever you want to do. I would disagree with the gentleman from Oklahoma about this being something we should be proud of. I mean, I think what this paves the way for is a process where we don't get much accomplished. You know, I'm reading that Senator Schumer is saying that the Democrats in the Senate are going to block all appropriations bills unless you fix sequester. I'm cheering them on because I think we ought to be fixing sequester before we move forward. The idea of a budget that sets limits on the appropriations process that are so unrealistically low, I mean, that will do great damage to our infrastructure, to our educational system, to the things that both sides say we care about, you know, tells me that there's not a single appropriation bill that you can bring to the floor that I think deserves to be supported. So I would have preferred that you spent this time trying to figure out a way to fix the sequester, and then come back and try to work out a budget maybe that we wouldn't all agree with, but at least would be good for our country. I think this is a budget filled with gimmicks. Again, we'll see how many gimmicks are still left after we go through it. But look, I think unless you fix sequester, nothing much is going to get accomplished in the appropriations process, and that's a terrible waste of our time. And I think we could spend our time more constructively. I'll yield back my.
If I may comment, Madam Chair?
Certainly.
And I appreciate the gentleman's comments. I think there's a lot of concern on both sides of the aisle about the sequester, and we look forward to working with folks on the other side of the aisle in an effort to try to figure out how to fix the concerns that exist on sequester, understanding that the budget is the first step in that process because it's the deficit neutral reserve funds and the path that the budget is able to lay out that allows you to get to that next step. And I sincerely look forward to working over the next couple of months and making certain that we're able to do that.
Yield back.
Thank you. Mr. Woodall.
Thank you, Madam Chair. It cannot go without saying that while we're here for the first time in 10 years to talk about a balanced budget conference report, we're here under the leadership of the very first Republican full committee chairman from the state of Georgia in the history of the United States of America. It is the very first time that Georgia has had an opportunity to lead, and I got to tell you, Dr. Price, I can't tell you how many folks said, Rob, quit talking about a conference budget report. It will never happen. It can't be done. For Pete's sakes, I've been here for 4 years with a voting card. I've never seen it done. In fact, I've never even seen it tried. It was such a bridge too far that folks didn't even try. I could not be more delighted, and not because there are not other opinions on this issue. There are, but because those opinions are so far and wide. Should we balance the budget? Should we not? Should we raise taxes by trillions? Should we not? Should we raise taxes by trillions and still not balance the budget? Or should we not raise taxes and should we balance the budget? I wish it were, as so many of our colleagues believe, that this is going to be the law of the land, and if only you and Mr. Yarmouth work your will together, suddenly we will have solved all the mandatory spending challenges in the country. I wish it were that easy. If the Budget Committee were entrusted with those responsibilities, I suspect we could sit down in a room and solve those issues tomorrow. This is the framework that so many other committees will get to work from, and far from not cutting a single tax loophole. For Pete's sakes, you envision tax reform so bold that even bills like the one I've sponsored, the fair tax that abolishes every single corporate tax break in the country, would get considered. Far from being a proposal that doesn't allow for debate and opportunity for members to get involved. You have this framework here. And only with this framework can we begin on these challenges. Let me ask you this. When the House passed its budget, we provided reconciliation instructions to almost all of our committees. We wanted to get every committee involved in the process of making the mandatory spending changes, because every member wants to change sequestration. Every member knows mandatory spending is really the problem. And so when we passed that budget in the Budget Committee, we instructed every committee to have a role in that. I know the Senate took a different step. Could you tell me how the conference report sorted out reconciliation instructions?
Yeah, it's an important issue because the differences between the reconciliation directives in the Senate version and the House version are probably the largest, some of the largest differences that were between the two chambers. The Senate, in their original resolution, budget resolution, charged two committees of jurisdiction that have jurisdiction over health care primarily, Senate Finance and the Health Committee in the Senate, with reconciliation instructions. On the House side, as you mentioned, we charged 13 different committees with instructions, with directives on finding mandatory savings. In the agreement, it was worked out that we would, in the House, do the same, and that is charge the House committees that have jurisdiction over health care issues, Energy and Commerce, Ways and Means, and Education and Workforce, with the same kind of directives that were offered in the Senate. So the House moved to in essence, the Senate position on that, to have the reconciliation issues be related to health care and those committees of jurisdiction over health care.
Okay. I think about the revenue levels of that Obamacare has provided. It's not lost on me that so many of the changes the President has signed to make changes to Obamacare have been changes that have decreased the revenues, right? Leaving all the things in there that are costing all the money. He's happy to sign the repeal of the things that eliminate the money. As I understand the budget framework that you all have conferenced, you've simply picked a level of revenue. That's the level of revenue that CBO expects, projects, and you say there are 1,000 different ways we can get there. The President's chosen one path with these Obamacare taxes. We don't think the Cadillac tax is the right way to go after those families that are getting good health care today. We don't think policy taxes are the right way to go, going after those folks who are trying to do the right thing today. We will achieve those level of revenues, but we're going to do it with common sense taxation, not this targeted, aggressive, going after those folks who are playing by the rules taxation. Is that
Exactly, and so we repeal all of Obamacare, all of its taxes, all of its mandates. I think it's important, again, to touch on the issue of growth. This country has seen in just the last 4 years a significant decline in the level of economic growth, economic activity across the country, and in the projection that the Congressional Budget Office has provided for the next 10 years, decreasing from 3% down to 2.3% over the next 10 years. Now, what does that mean? That means that the average growth in this country over the last 40 years has been about 3.3% per year. That's the growth that allows the economy to continue to increase, allows jobs to be created, allows resources to be able to come to the federal government in the form of tax revenue. For every percent decrease in that growth, when you go from 3.3 to 2.3, you decrease revenue to the federal government by $3 trillion. $3 trillion. All other things being equal, if you got back to the 40-year average, you'd have another $3 trillion that the federal government could be able to utilize for the kinds of things that all of us so dearly desire. So we believe the way you get out of this is not by simply restraining spending, which is important, and reforming programs that are going broke, which is important, but by growing the economy, putting in place the programs that allow for the growth in the economy, and that's how you get to the revenue line.
Well, I have great respect for Mr. Yarmouth, and I happen to agree with him that what has happened with wage stagnation in this country is tragic. I was with some of my community bankers earlier today. They said they're getting out of the home mortgage business, thinking about trying to get folks into homes, that it's just gotten too risky to do, that the regulatory environment is so geared towards failure that they just as soon not try. I talked to one of my mortgage folks. He said, Rob, the good news is I've hired 3 people in the last year. The bad news is they've all been on the compliance side of the shop. When you have a small operation, about 15 folks working in that operation, you add 3 new people, and not a one of them is geared towards productivity increases. In fact, they're all geared towards stemming productivity declines. Wages have no place to go but down. Only with the kind of growth that you're talking about does productivity increase. I can't increase my wage unless I can increase our productivity. I can't tell you how proud I am to go back home and talk about the productivity increase that you and the Budget Committee, both minority and majority, have brought. First conference report that we have seen in my 4 years in Congress. First balanced budget conference report in 10 years. First opportunity to begin appropriating at this time of the year that we've seen since the 1970s. Congratulations. I should have known if they'd put a Georgian in charge, things were going to go well on day one, but I just hope you are as proud of your work product as the rest of us are of you. I yield back, Madam Chair.
Mr. Polis.
Yeah, Mr. Yarmouth, Mr. Price said that this repeals Obamacare and repeals the taxes of Obamacare. Is that what you said, Mr. It repeals Obamacare and the taxes? That's what Mr. Price said. So what I don't, and he said it uses the savings, but the part that I'm confused about is it seems like if you repeal Obamacare and its taxes, you're just digging a bigger hole, because those Obamacare and everything associated with it saves over $200 billion. So if you were to repeal them, doesn't it just makes the rest of the whole bigger? So what sort of mirrors here there is because I know him to be an honest man. So what kind of mirrors is he using to say that is?
I think you're absolutely right. The CBO said it's a little over $100 billion in the first 10 years, over $1 trillion deficit reduction in the second 10 years.
That was from its inception, but now we're talking about through year 15 of it. So I think, right.
Yeah. So you're foregoing all of those deficit reductions if you repeal the law. And also you can't talk about repealing Obamacare without talking about the ripple effects throughout the economy. If in Kentucky, the Affordable Care Act is going to create 44,000 new jobs in the next 6 years, that is economic benefit that will eventually accrue to the federal budget and the taxpayers, just as it will. Again, the $30 billion worth of added economic activity. Then you talk about the human cost. What we will be doing if we repeal Obamacare is we will be adding to the cost of every senior's health care. The donut hole will return to its original size for prescription drugs. All of the benefits that have accrued will disappear. The budget proposes to block grant Medicaid, which means there will be, first of all, the expansion of Medicaid will disappear, and then funding for Medicaid will decrease, puts an added burden on the states. So all of these things, we can analyze them strictly from the perspective of what they would mean for the federal budget, but we have to talk about what they mean for the entire economy. And if you take $5 trillion out of the economy over 10 years, you are absolutely hindering growth opportunities. And when clearly the chairman and I and everybody in this room believes that we have to improve economic growth in the country, that's ultimately the answer. But if you take money away from infrastructure, which we know expands the economy, if you reduce spending for education, if you reduce spending for job training, those are things that are not going to help the economy grow. Those are things that are going to hinder the economy.
Mr. Price, can you, so I guess first of all, does the budget repeal the entire Affordable Care Act, everything that was in that bill?
It does.
Okay.
It assumes that in the 10-year
Right.
projection.
So in repealing that, does it create an additional hole in the budget north of $100 billion that you have to fill somewhere else?
It assumes that with that repeal, the CBO, the Congressional Budget Office, tells us that what that saves over a 10-year period of time.
Are you telling they say that repealing the Affordable Care Act saves money?
Yes, exactly.
Then why does the scoring that we're looking at say that repealing it would cost money?
Because it's a dynamic process. Let me give you an example. For example, the Congressional Budget Office says that about the equivalent of 2 million FTEs are lost over a 10-year period of time because of Obamacare. You've heard of the 29ers and the 49ers, the folks who are down to part-time labor, and the companies. You having been in business before, you know that companies respond to what we do here. And when the law sets the limit of 50 employees, and that's if you go above that, then you're obliged to be subject to the regulations of Obamacare. So people get to 48, 49 employees, and they stop. The Congressional Budget Office tells us that that kind of effect has a detriment to the economy of the equivalent of 2 million FTEs over a period of 10 years. When you lose that kind of job creation, then you lose revenue coming to the federal government.
So I think what you're saying is there's a new way this is scored than the scoring that I'm looking at. Well, I mean, the scoring that is associated with the Affordable Care Act, if it were to be repealed in its entirety as contemplated on this in this budget, it would increase the deficit by over $100 billion, in large part because you're repealing all of the revenue sources associated with it.
We believe that, again, to Mr. Woodall's question, that if you put in place appropriate pro-growth policies, that you not only replace that revenue, but you gain more revenue to the federal government. Now, the Congressional Budget Office provides us the estimate that we would replace that revenue with our policies.
Well, and of course, people, do they also look at things like if people lose their health care, they might have to go on, more people might have to go on Medicaid and that sort of thing?
The models that the Congressional Budget Office uses accounts for all those kinds of things, but keep in mind that we don't repeal Obamacare so that people are left out there without the kind of coverage that they want for themselves and for their family. We repeal it so that people are able to gain the kind of coverage that they want.
Well, those are policies that are not in the budget. That's just what you're ordering the committee to work miracles there, and we all hope they do. But you know, those, you don't have those policies in the budget. I mean, budgets are not policy documents. You're saying, committee, you do better for less. I certainly hope they succeed. But in the meantime, you know, by the accounting that I have, it looks like repealing Affordable Care Act only increases the deficit. And I'll be, you know, curious to look at the reports that you've indicated to try to see how you're rebutting that, because obviously the devil's in the details there. But again, there's a lot of revenue associated with the Affordable Care Act, and each one of them has people who like them and people who don't, and there's various bills that the Republican majority has brought to the floor with regard to medical device tax and other other items in there. But again, clearly, when you're foregoing revenue, I understand why the foregoing the expense side of Obamacare would reduce the deficit, but foregoing the revenue side would increase the deficit. Just seems like sort of common math to me, but I'll look forward to looking at the reports that you've indicated, and I yield back the balance of my time.
Thank you.
Thank you, Mr. Chairman, and I thank both of our witnesses today. And let me just ask you, just for the benefit of a historical perspective, when is the last time that a unified budget resolution came to the Congress?
There are varying accounts on this. 2009 is the last time there was a budget agreed to between the House and the Senate. The last time as I understand, the last time we had an agreed to balanced budget between the House and the Senate was in 2001.
In the 2009 budget, did
Balanced
that
budget over a 10-year period of time.
Very well.
Sorry.
And in the 2009 budget, did Congress actually pass a conference report? I don't recall. I do remember the House and the Senate both agreeing to budgets, but did they ever sit down and agree to the differences between the two budgets?
They agreed to a construct because you'll recall they used reconciliation for something in March of 2010 that
I do recall that.
significant.
I do recall that. Now, Mr. McGovern alluded to the fact that this was Republicans negotiating with Republicans in 2009. Would it not have been Democrats negotiating with Democrats?
I don't think that we were asked about that agreement.
Yeah, but to the best of my recollection, there was no Republican input in the 2009 work product.
No. And as Mr. Cole said, this is budgets tend to be, because they're visionary documents about how you would solve the challenges that we face, and we differ from an ideological standpoint, these tend to be partisan battles.
That is an accurate observation, and I appreciate the gentleman making that. I do just want to note that you've got Section 6203, the policy statement on tax reform. Now, Mr. Woodall and I both, although we differ on what we would like to have seen you explicitly say on tax reform, I think even though we're in a different place on tax reform, fair tax, flat tax, we could both agree on the principles that you've laid out, and perhaps it was the wiser course rather than picking your favorite pathway that you apply the principles, and then it's up to us to be able to deliver the product that will work within the constructs of what the Budget Committee has put, or what the budget resolution does. Is that correct?
Yeah, that's correct. We work in concert with the authorizing committees and come up with language that can be supported.
Now, the summary document that we were provided as the hearing began, one of the last things mentioned on it, it says, calls on Congress to pass a balanced budget amendment to the Constitution. Since I haven't had time to find that in the more detailed report, what do you envision that looking like?
Again, it charges the Committee of Jurisdiction, in this instance the Judiciary Committee, with coming forward with a balanced budget amendment that the House and the Senate have an opportunity to vote upon.
And is there a time frame where that would likely occur?
This year.
This year. All right. Well, congratulations. I mean, it is a big deal. The gentleman from Georgia has already applied all of the Georgia Chamber of Commerce talking points, but I also want to point out that you are a senior member of the Congressional Doctors Caucus, and clearly this is something that required a physician's touch to get it done and get it done correctly. Mr. Chairman, I'll yield back.
We do have fun up here, Tom, even if it's doctor humor. Mr. Price, I don't know whether you know this or not, but we have this guy, Steve Stivers, who's been an addition to this committee, and he's really done, these next couple members have really added a lot to us. And I'd like to now make sure I acknowledge Mr. Stivers, came from Financial Services, doing an awesome job for us. Gentleman's recognized.
Thank you, Mr. Chairman. I appreciate both of you gentlemen for being here and talking about your alternative views on the budget proposal that's before us. And I especially want to thank Chairman Price for the last bullet point that the gentleman from Texas just talked about. I've been in Congress now, I'm in my third term, and we've only had one vote on a balanced budget amendment. In that time, 7 states have added their mark on the wall about requesting the federal government pass a balanced budget amendment. Now 27 states have sent resolutions to Congress asking for a balanced budget amendment. So I appreciate this effort. I appreciate everything that you do to balance the budget over 10 years, but the long-term piece of this is how we move forward as a country and stop burying our kids under a mountain of debt. I have a 2-year-old, a 2.5-year-old, and a 5-year-old, and I am embarrassed that we haven't made the structural changes that keep the federal government from stealing from our kids and giving to current generations. It's shameful, it's wrong, and we've got to fix it. And so I just want to thank you for your work, and I look forward to, there's tough decisions in this budget document. I appreciate that. That's why my constituents sent me to Washington to make tough decisions, and they respect my judgment, and every 2 years they get to decide if they want me back. And I am proud to support this budget, and I appreciate your hard work. I yield back the balance of my time, Mr. Chairman.
Yeah. Thank you, Mr. Chairman. I just, will be very quick. Thank you, Mr. Armour. Thank you, Chairman Price. I mean, I think it does. I think the most amazing thing to me is that we have to actually have an amendment to have a balanced budget. I mean, I come from a state in which we have to balance the budget. So, I mean, to actually think about we would have to do an amendment to balance a budget is just beyond the comprehension of I'd say, the vast majority of Americans. So I just appreciate the work that both of you put in. Thanks, and look forward to supporting it.
See, all dollars and cents. He turned into our guy. Mr. Burns?
Thank you, sir. I want to congratulate you as well. I was in the Alabama legislature. We passed a balanced budget that balanced in that year, every year, on time. 49 states in America do that. I'm going to tell you, it's not easy to do, too. You have to make some tough decisions like you do in your budget. For several years, I was the chancellor of post-secondary education in Alabama. And during the Great Recession, the finance director of the state of Alabama came to me. He didn't say, can you, would you? He said, you've got to cut $75 million out of your budget. Not $75 million out of the growth, $75 million absolute. That was an enormous amount of money for us. And I got every one of my college presidents around the table, and I said, all right, no whining. Let's go take a fine pencil to our budgets and find a way to do it. And we did it, and we did not cut one single essential program. We kept it going. I come up here to Washington, and I'm appalled. I see waste everywhere. There is an agency, I'm just going to pick one, I could pick dozens. It's the National Marine Fisheries part of NOAA. They're the ones that set the policy for America about where we get to fish, what we get to fish, et cetera. We allocate over $900 million to this agency. And yet when they go to sample for a reef fish in the Gulf of Mexico, they don't know how to sample on reefs, so they don't sample for that fish on reefs. They look for a reef fish on sandy bottom. You know what? They don't find them. Yet the little bitty old University of South Alabama in Mobile, in my district, figured it out a long time ago with a much, much, much smaller budget. Now, how does this happen? This happens because we print money, and we don't have the discipline to make government work. And if you don't have the discipline to make it work, you not only have government that's inefficient, it's ineffective. Look at the VA. It's disgraceful. We had a hearing on that yesterday. It's one of the most disgraceful things I've ever seen. Bloated administration, bloated budget, and look how they're failing, harming, killing our veterans. So it's not just important to have a balanced budget because you want to make sure you don't spend more than you bring in. It's important to have a balanced budget because it makes you do your job better. So I appreciate the fact that for the first time in over 10 years, pick whatever year you want, over 10 years, y'all have done that. Not everything in here is what I want or what you want. But if you're going to pass a budget of this size, there's no way to get perfection for all of us. And this is a pretty good job at getting as close as you can. and I appreciate the hard work everybody put into it, and I look forward to voting for this on the floor. Thank you, and I yield back.
Mr. Chairman, I think you see why these members are on this committee. They're deeply committed to the processes that you talked about today. I'd like to begin my questioning, and I'm intensely interested in probably picking the brain of the chairman about some of the processes. This reconciliation process is really a process that is not going to become law. Is that correct?
The reconciliation directives within the budget resolution itself do not become law. They direct the committees that are identified in the budget resolution to go find the solution for a particular area, and then those committees report back to the budget committee, the respective budget committees in the House and the Senate, then bring a piece of legislation to the respective chambers, House and Senate, and that's the vehicle for becoming a law. Budget resolution is not signed by the President. Those reconciliation bills become, in this instance, a House resolution. That would have to go through both chambers and be signed by the President in order to become law.
And then that budget reconciliation process, then we understand, and we would follow as we are required to do in this legislation by about July?
July 24th is the date that
July
these committees have to
24th.
report.
So you put in place a budget which drives behavior, what I would say is behavior of these committees. It is not the law. Tell me how you, in essence, would view if a person said, by voting for this, you're funding Obamacare.
You're funding Obamacare?
Oh, that's a common thing that is said throughout a number of districts. By voting for this budget.
It's just not true.
Just not true.
What the budget does is, as we mentioned, is to repeal Obamacare entirely. It's taxes, it's mandates, it's requirements.
So it's the reverse.
It's exactly the reverse. Now, the reason that somebody might have some concerns about it is that the budget resolution, as mentioned, doesn't become law, so it directs the committees of jurisdiction to accomplish that activity. And we think that that's important and a priority, frankly, for the American people.
So it would be a demand put on the Budget Committee that simply was not part of the process.
Exactly. In fact, not possible to be done.
Not possible. So tell me how you look at and treat what might be mandatory spending. You do discuss that. Do we ever vote on a mandatory budget?
The budget itself, about 2/3 of what we spend each year in this country is what's considered mandatory spending, primarily Medicare, Medicaid, and Social Security, and interest on the debt, but Medicare, Medicaid, and Social Security. Those programs are what are called mandatory spending or automatic spending. They just keep spending based upon a formula unless Congress and the President agree to a change in those programs.
That would be through policy, not through appropriations, probably.
Exactly. And a piece of legislation that would come forward and provide reforms for those mandatory programs. We think those need to occur. In fact, in our budget, we identify areas where we think we need to find appropriate savings and save and strengthen those programs, Medicare, Medicaid, and Social Security.
Awesome. Well, these are very important points for us to remember. It's really a vision statement that comes directly from whoever the majority might be, whether it would be our Democratic friends, or whether it be our Republican friends. And in this case, it's now a House and a Senate that would be Republican. And you felt very strongly, and I believe you stated from the beginning, not just when you were running to be the Budget Committee Chairman, which this supposed you sought.
Yes, indeed.
And in fact, you then, in essence, gave some ideas about what you would do, lead us to a balanced budget, would lead us to doing some things in a wise and conservative manner, up to and including several weeks ago, you predicted that you would be successful with the Senate.
Yes, and it's been a real privilege to be able to represent this conference, along with the conferees, in a House-Senate budget conference, to where we can get to that first balanced budget over a period of 10 years that has been agreed to and will be brought to the floor of each chamber since 2001. And it's a privilege to be able to put forward the solutions, the positive solutions that we believe can help get this country back on track.
Well, as a colleague of yours, I want to tell you thank you. I think you lived up to not only what you said you'd do, but I think you led with real leadership and led through telling people what we were going to do and then doing what you said. And I'm really proud of you, and I want to thank you.
Thank you.
Mr. Yarmouth? Yes, sir.
While we have very different visions, as we've expressed, I want to say on behalf of myself, Ranking Member Van Hollen, and the rest of the members of the committee that Chairman Price has run the committee in a very respectful, very dignified, and civil way. Our conversations and debates have been very lively and very thoughtful, and Mr. Price has done, Dr. Price has done a terrific job of facilitating the work of the committee.
If I may return the compliment to Mr. Yarmouth and Mr. Van Hollen, who's the ranking member. The Budget Committee is a very ideological committee, there's no doubt about it. We put forward different visions. But we do so in a way that I think is a wonderful example and a model for the country, and that is to disagree without being disagreeable. We carry on robust debates about how what direction each side thinks is the way to move forward to solve the challenges that we face. But we do so in a very respectful way, and I'm honored to serve with him.
And you're a lot like the Rules Committee. Occasionally you do it at 2 in the morning. Like once a year, you're up till at least 2 o'clock.
That's when the Bourbon Caucus came.
Well, that is. Let me tell you, both of you have been a delight to be here with us today. And I wanted both of you to know that on Thursday night, does gentlewoman have her microphone on? Thursday night, you want to help me?
Well, I'm going to get my portrait hung here, and I saw it yesterday because I didn't want to, for the first time, see it and fall into a fetal position on the floor, screaming for help. I'm really honored that my grandchildren will be here, though, and really excited about that. And we miss Bob.
Yes.
It'd be wonderful to have my children and grandchildren here. So thank you for.
Do you know one other thing about this that I learned? I know we're prolonging this misery for our witnesses, but evidently the artist that did this is the same one that did my father's as FBI director. That portrait that hangs at the FBI headquarters.
He's really very talented.
Well, we'll see.
Well, let me put it this way.
Have you sneaked a...
He was pretty well talented before he made me an absolute blonde. But other than that,
Do you have...
I'm not complaining.
You have rhubarb in your hand?
No, I'm going to tell you, when a girl from the coal fields of Kentucky gets to hang up in the capital of the United States of America, she's got no complaints.
Well, the reason why we're doing this is I hope Mr. Yarmouth will be here. It'll be at...
5:30.
5:30.
5:30.
Thursday?
5 o'clock? 5:30 is what I think, yeah.
I'm providing everybody
We won't
on this
all be
committee
here.
a viewpoint of this. It's Thursday, and I think it's going to be really a nice opportunity for us to once again, a person that we admire, a person that's put in a lot of long hours. At 2 in the morning, I can tell you, I've seen Louise every hour of the day and night, and she's awesome, and she deserves it, and we're going to put it up here somewhere, but I get to look at her here and look at her there. It's just going to really be a good thing. But I think that she wears the heritage of Kentucky very well, not just representing Rochester.
I do indeed.
Yeah.
In Kentucky, they always tell us to never try to rise above your raisin.
Yeah, well, are you going to sing
Am I
for
right?
us?
My Southern guys know what.
You going to sing for us tomorrow night?
No, I'm going to spare you that grief.
Spare us that, okay.
But
Well,
thank you very much.
Yes,
Mr.
yes, ma'am.
Chairman.
I wanted to acknowledge that, and I really did want to say thank you to both of you, your professional conduct, demeanor. If you'll do me a favor and tell Mr. Van Hollen, I accidentally told him yesterday, we'll see you tomorrow, and he said, what am I doing wrong? And I said, no, it'd be right, but if Mr. Khan will make sure that he knows that I missed him, and I want to thank you both very much. It's with kind of a happy feeling I say this, but Neil, you're done with us. You're going to graduate from the Rules Committee, and Neil is going to be with the U.S. Chamber. He's going to handle U.S.-India relations, and so his time here has been well spent.
We have enjoyed working with Neil so much. He's one of the nicest people.
Yeah, he is.
He likes chocolate. We
Oh.
bring him down some from Rochester on occasion, and it's really just an all-around nice guy, parents of two beautiful boys.
Yes, and
And-
beautiful
and
young
he-
wife.
And he's not going to have to work these atrocious hours, so,
Maybe not,
yeah.
maybe not.
Good luck, Neil.
Well, we
Forever.
want to wish you the very best from the Rules Committee. Don't forget where you're from. What's the saying?
Don't try to rise above your raising.
So, don't rise
If
above
anybody
your-
can figure that out,
But we're going to miss you, and a sincere thank you on behalf of not only this committee, but Chairman Dreyer and the others who've known you well. We appreciate you very, very much. Last thing I had to say was my communications director gave up on me, but she was over here. She's now in an empty seat. But she had her mama here, and Caroline Booth and her mom, both from Albuquerque, New Mexico, sat in here, watched this hearing today, so Miss SMU got her mom here, and so we're going to have fun. Good. I want to make an announcement if I can, and that is that we're going to try and put all of our stuff together. We will come back no earlier than 6:15, I've been told, but what we're going to do is try and look at when the votes might be scheduled tonight and come back. I hear it's going real fast, but not before 6:15. But we'll try and come back about 30 minutes before that. We'll provide notice. Miles does a good job. Have you noticed that?
I do, and I've got grandchildren coming in, so I've got to get stuff in the refrigerator.
I bet that you will be excused. You'll be. Listen, thank you very much, and to our members for an exceptional day. We'll now be subject to the call of the chair.
I've got an amendment.
Yes. We still have to read the motion.
Yeah. Rules Committee will come to order, and thank you very much. The chairman will now be in receipt of a motion from the gentlewoman from North Carolina.
Mr. Chairman, I move the committee grant H.R. 1732, the Regulatory Integrity Protection Act of 2015, a structured rule. The rule provides 1 hour general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Transportation and Infrastructure. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment, an amendment in the nature of a substitute consisting of the text of Rules Committee Print 114-13, modified by the amendment printed in Part A of the Rules Committee report, and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. Rule makes an order only those further amendments printed in Part B of the report. Each such further amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part B of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of the conference report to accompany S.Con.Res 1-1, the concurrent resolution on the budget for fiscal year 2016. The rule waives all points of order against the conference report and against its consideration. The rule provides that the conference report shall be considered as read. The rule provides that the previous question shall be considered as ordered without intervention of any motion except 1 hour debate. Section 3 of the rule provides that Section 604G of the District of Columbia Home Rule Act shall not apply in the case of H.J.Res 43, disapproving the action of the District of Columbia Council and approving the Reproductive Health Non-Discrimination Amendment Act of 2014. Section 4 of the rule provides for consideration of H.J.Res 43, disapproving the action of the District of Columbia Council in approving the Reproductive Health Non-Discrimination Amendment Act of 2014 under a closed rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform or their respective designees. The rule waives all points of order against consideration of joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. Finally, the rule provides that pursuant to Section 604H of the Home Rule Act, a motion to recommit is not in order to the joint resolution if under consideration while the act of the D.C. Council is within the congressional review period prescribed in Section 602 of such act.
Thank you very much. You've now heard the motion from the gentlewoman from North Carolina. The committee is now prepared for amendment or debate. Gentleman from Massachusetts.
I have an amendment to the rule. I move the committee grant H.R. 1732 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
All right, discussion? Those will now vote on the McGovern amendment. Those in favor signify by saying aye. Aye. Those opposed, no. No. The noes have it, noes have it. Further amendment or discussion? The vote will now be on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, the ayes have it.
Roll call?
Gentleman asks for a roll call vote.
Ms. Fox.
Aye.
Ms. Fox, aye. Mr. Cole, Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Stivers. Aye. Mr. Stivers, aye. Mr. Collins. Aye. Mr. Collins, aye. Mr. Byrne. Aye. Mr. Byrne, aye. Mr. Newhouse. Aye. Mr. Newhouse, aye. Ms. Slaughter.
No.
Ms. Slaughter, no. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
8 yeas, 3 nays.
The motion is agreed to, and accordingly, the gentleman, Mr. Woodall, will be handling this for Republicans.
Mr. McGovern for the Democrats.
Mr. McGovern for Democrats. I do not anticipate any other meeting of this week except for tomorrow night. The action in the Rules Committee will be the portrait hanging.
Hanging of Louis.
The hanging of Louis. The hanging of Louise Swatter. Well, we may have that up at some point. Louise, Louise, it is something to look forward to, and a hearty congratulations. And we look forward to it tomorrow night.
I appreciate it very much.
We have now completed our work pending that opportunity to be together tomorrow night. Thank you very much.